Welcome to Shanmugam IAS Academy, and today's topic is about the false merit reservation, which we are continuously reading in the newspapers about the reservation system. What exactly about this we are going to discuss in this particular topic. This comes under the GS paper 2 mains, and which is very important. And these fundamental rights, these articles, these amendment acts, which I am going to discuss in this topic, is important for both is prelims point of view, so you need to be very careful, be focused. So let's go into this topic. That is actually the context here is the Supreme Court of India recently this ruling on all the Indian quota deserves closer attention for a reason other than its impact on postgraduate medical admissions. So this is what the Supreme Court has told. We have to deserve a closer attention towards the Indian quota systems. So this is what is told by the Supreme Court of India. So why this is there, why we are studying about this topic here is because of this because in this detailed order the providing reasons for its ruling, which upheld the constitutional validity of reservation for other backward classes in the all India quota for national eligibility come entrance test, that is shortly NEET. We all know for undergraduate and postgraduate medical admissions this is happening, and we all know in Tamil Nadu one issue has happened. Now governor has written back the bill which was given by the state assembly for its reconsideration. So issue is going on. Supreme Court also has told something here. So for this only we are studying about this topic today, and underlining that reservation is not at the odds of the merit, but further it is a distributive consequences, such as merit cannot be reduced to narrow definitions, that is depending upon the performance, because in this type of open competitive examination and the high scores is an examination and not a proxy of merit. This is what here we have been differentiating in this reservation. And it's also said that the merit should be socially contextualized. So this should be socially contextualized because this is an instrument that advances the social goods like equality that we as a society value. We should value this has to be an equality as a social good, and the judgment has the potential to settle a long, fractious and futile debate in our country. So because that is what, that is merit versus the reservations. So this is an potential debate in our country right now which is going on. The order of the two judge bench lays to rest a popular misconception of merit while advancing an interpretation that is consistent with our constitutional ideals of equality and social justice. So this is what has been told by the two judge bench. And in this topic we are going to study about the fundamental rights, the constitutional amendments, which are very important in the prelims point of view. Just get it, note down those points when I will discuss that. So what is about the formal and substantive equality here. So that is the principle of equality is a fundamental assumption of democratic society. So this is the principle of equality which comes under the Article 14, and it is well recognized to be corollary exist between the equality and also non-discrimination. So this is how we will differentiate here, and to understand what we should first examine what we mean by equality and explore the characteristics that make it a progressive universal moral and legal principle. So the traditional approach of national legal systems was to employ the concept of equality as a system of formal rules. And there is also another thing, the more recently the constitutional reforms which were informed by the increasing academic debate have sought to develop a more sophisticated concept of equality and have taken into consideration the richness and the variety of modern human relations and the subtle characteristics which can lead to the discrimination and the disadvantages characteristics here. And next thing, the constitutional validity of reservation for the other backward classes in the all India quota. This is also one of the point. So in the all India quota, which refers to the judicially created category where 15% of undergraduate seats and 50% of postgraduate seats are filled on a domicile free and all India basis. This is what all India quota system offers, and the government of India has recently decided to extend the existing scheduled caste and scheduled tribe reservation within this category, and that is to provide for OBC reservation as well. This is what government of India recently decided. And another set of writ petitions have also challenged that the notification existence of EWS reservations even as the hearings on the 103rd Constitutional Amendment Act were pending. What exactly this 103rd Constitutional Amendment Act is about? So the constitution, this is about economically weaker section reservation act. We all know that. So here a newly instituted, that is the inserted articles, that is article 15 class 6 and 16 class 6, which allows the reservation for the economically backward sections in the unreserved category. So this is important about this 103rd Constitutional Amendment Act. This is the inserted articles in 15 class 6 and 16 class 6 of the fundamental rights. This allows reservation for the economically backward class in the unreserved category. The unreserved category is important here. So that was still pending, and though the writ petitions have also challenged the tenability of rupees 8 lakh as the income limit for EWS reservation. So the court, in the view of public health implications of the delay in the medical admissions, it upheld that the admission notice and the listed for March are hearing on the validity of the rupees 8 lakh limit. So this is what told by the court. So what is the issue? Issue is with merit versus the reservations. So the court took this opportunity directly to address the issue of merit versus reservation in a length. So it said the critics of affirmative actions have argued that reservations violate merit. So they are saying, the critics, the reservations which are there in the country in the form of all India quotas and reservations which violate the merit. But the defenders of reservation too often concede this, but argue that affirmative actions serve the other goals such as social representation. So 2 points are here. The critics saying this violates the merit, but what is the defenders were saying? This we have to see it in the form of social representation. So these 2 points are important. The judgment begins by recalling and reaffirming the principle of substantive equality rather than formal equality that underlines our constitutional promise of equality of opportunity. And some of the cases, landmark cases which we are going to discuss here, the court builds on landmark cases such as State of Kerala versus N.M. Thomas, KC Vasant Kumar 1985, this was a case, important case, and Indira Shanwe versus Union of India, which is in the 1992, to reiterate the sharply the provisions of the reservation which exactly given in the article 16 class 4 of the constitution is not an exception but an extension to the principle of equality enunciated in the article 16 class 1. This is told, this is the judgment provisions which was given in this Indira Shanwe and the Union of India case of 1992. The reservation is one of the measures that is employed to overcome these barriers. Which are the barriers? That is to achieving the aspiring goal of genuine equality of opportunity and status among all the citizens. This is what we need to achieve. To overcome these barriers only we have been employed these type of quotas here, and that is why we are discussing here. And the individual difference may be a result of privilege, fortune or circumstances, but it cannot be used to negate the role of reservation. And second is the judgment contributes to the specification mechanisms. I have already told you this to be the social privileges of work. And in the Justice Chinnappa Reddy in Vasant Kumar versus State of Karnataka, which is in 1985, has critiqued the purely economic understanding of claims for reservation by emphasizing the embedded and rigid nature of the socio-cultural and institution of the caste. And it draws upon the K.V. Shyam Prasad to recognize that perhaps for the first time the role of cultural capital, and the cultural capital, what exactly it ensures? It ensures that a child is trained unconsciously by the familial environment to take up higher education or high post commensurate with their family standing. So this is the main background, main thing of this cultural capital, which is saying this is that it's a child which has to be trained in unconsciously with the familial environment to take up higher education or higher post commensurate with their family standing. So what we need to rectify here, the stereotypes and the skills here is, that is, it recognizes that there is a need to rectify the prejudicial stereotypes about the skills of persons belonging to the weaker sections too. But it relies on the 2019 decision in the B.K. Pavitra versus State of Karnataka, also authored by Justice Chandra Chud, and it held that benchmark of the efficiency of administration is not some disembodied but it's an abstract ideal which is measured with the performance of the qualified open category candidate. This is important. The performance of this is measured based on the performance of a qualified open category candidate. So in the conclusion, we can say this: the recognition of social privileges that hide behind the merit also important. The demand for caste census that can document the dynamics of privileges and the caution against the that is conservative policies demands, and also the Brahmin schemes that are mushrooming across our political landscape. So everything is so lying behind this. So the caste census, there is a editorial which I have given on caste census too. If you have any doubt, you can go and watch that video too. And mainly here the merit you have to see as an important factor, and also the demand for the caste census is also a document, and the Brahmin schemes that are mushrooming across our political landscapes is also one of the factor. So mainly here the efficiency of administration in the affairs of the union or of a state must be defined in an inclusive sense. It has to be inclusive in nature, and the diverse segments of the society and find representation as a true aspiration of governance, and that is by and it is for the people. It has to be like that. So in this way we can write this answer, and also some of the important points which we prelims they can be asked about this fundamental rights, this 103rd Constitutional Amendment Act, what exactly it is saying, and what everything we have studied here, and some of the cases which will be very useful for writing of the answer. So if you have any doubts, inquiries, just tell us in the comment section. Thank you so much for watching this video. Thank you.